You're counting into me? Yeah, pics, lots of pics. This is a from the Ada County Courthouse in Boise, Idaho. This is where Bryan Kohberger, the man accused, he stands accused right now of murdering 4 University of Idaho students. We can't say their names enough. They are Madison Mogen, Kaylee Goncalves, Ethan Chapin, and Xana Kernodle. He is expected to change his plea after more than 2.5 years to guilty in just a short time, in a little less than an hour from now. This is a seminal moment. I cannot overstate the gravity of this moment. We were preparing for a trial in this case, a death penalty trial to start in this case later this month. There were going to be sealed hearings at the very end of July, and then jury selection, voir dire, was going to start on August 4th. That is not going to happen now if Judge Stephen Hippler accepts this plea agreement that was reached apparently over the weekend or late last week between the state and the defense. This is somewhat surprising, but also somewhat not. The defense in this case has been trying to get the death penalty stricken for some time now. They filed a number of motions over the last several months asking Judge Stephen Hippler to strike the death penalty. They said that Bryan Kohberger had autism spectrum disorder, and that should make him ineligible for the death penalty. They said that the state of Idaho, the prosecution, fed them a bunch of discovery, 68 terabytes of discovery. If you can't wrap your mind around that number, that's a huge amount of discovery. That is, just think about 68 1 terabyte hard drives, you know, those little cases you could buy at Best Buy, full of information. They were given 68 of those. They said, we can't get through all of this, so you should strike the death penalty. They made a number of different arguments. And then came the Dateline special in May that aired a lot of the evidence in the state's case, and Judge Hippler was furious. The defense was furious. And we were expecting possibly for them to ask to strike the death penalty again based on that leak of evidence. And there was an investigation underway, a special prosecutor appointed to investigate that leak to determine who did it. We don't know the results of that investigation or the status of it, but we know it's underway. Then last week, the defense's request for a continuance was denied. The defense's request to introduce alternate suspects in this case. They wanted to introduce 4 alternate perpetrators to the jury at trial. That request was denied. So their avenues of defense were cut off in this case significantly. Word is that the defense and Taylor went to the prosecutor, Bill Thompson, and said, hey, if he pleads guilty, will you take the death penalty off the table? Bill Thompson considered that. He went to the families. Steve Goncalves, the father of victim Kaylee Goncalves, he brought it up apparently to the family in a meeting briefly last Friday. The family voiced their opposition to it, and then Sunday apparently the families received a letter. The Goncalves family is furious about that. I'm going to read the latest statement from them in just a moment. But the Chapin family, the family of Ethan Chapin, they are here, and they arrived just a short time ago, right before we came on the air. They are supporting this plea agreement. So they are here in support of it. We're still waiting to hear what the parents of the other family members are saying. Ben Mogen told CBS News, Maddie Mogen's father, that he is supporting this plea agreement. So it'll be interesting to see what happens when court begins in earnest. Right now I want to bring in our panel. We have a great panel with me today. Tara Malik is a criminal defense attorney and former prosecutor, and Bradford Cohen has covered and covered a lot of cases with us here on Law and Crime. He is also a high-profile defense attorney, also an entertainment attorney, represented a lot of high-profile defendants. So Tara, I'll go to you first because you're based here in Idaho. I want to know what you think about the defense reaching out to the prosecution at the 11th hour, so close to trial, and saying, hey, let's make a deal. What do you think, how much of a factor do you think the Dateline leak, that leak of that huge trove of evidence, Tara, and the investigation that the judge wanted, the appointment of a special prosecutor to investigate the source or sources of that leak, how much do you think that played into the prosecution being willing to make a deal? I want to read the latest post to the Goncalves family page. As I mentioned, they are furious. They have said from the very beginning they wanted the death penalty in this case. As we all know, if Bryan Kohberger went to trial and was ultimately convicted and it went to the penalty phase, which it would, since this was a death penalty case, the jury would consider whether to give him life in prison without parole or a death sentence. It only takes one juror to say, I don't want to do that, I don't want to vote for the death penalty, and it would be life without parole. Let's look right now at this. I'm going to read it to you, actually, this latest statement. They've been urging people to call Judge Hippler. They want him to reject this plea agreement. They wanted a trial. They wanted answers. They say, right here, right now, we dig our heels into the earth and carve a line deep in the dirt. This ain't justice. No judge presided. No jury weighed the truth. Thompson, meaning Bill Thompson, the Latah County prosecutor, robbed us of our day in court. No negotiations, no jury of our peers, not even the pretense of cooperation and fairness. Cowardly men, gutless men, they scatter like roaches when the battle closes in. And Thompson, he's retiring on the deal, his shadow slithering toward the exit, leaving only the stench of his betrayal. No spine, no shred of honor. He didn't have the basic decency, the plain human courage to face the families, to meet our eyes and ask, how do we make an offer that works? Instead, Thompson cut his deal with the devil. His negotiations didn't require anything other than a simple guilty plea, allowing him the leeway to blame the same people you are paid to protect. You betrayed us, Thompson. Your deal fails to shield the innocent. You could have stood tall and made damn sure the blame stayed where it belongs, not on us, not on the broken survivors, still carrying the weight of your repeated failures. This is our courtroom now. This moment, this stand, our voices rise to every American who will listen. we would have provided basic protection for the roommates, the best friends, the fallen vet. God rest his soul, and every soul affected in our shattered community. This is what they wanted. First, truth, spill it, BK, every sickening detail only the killer could know, the kind that twists your guts just to hear, but turns even simpleton pro-burgers against you. Pro-burgers are what people online call Bryan Kohberger's supporters, the people who have been saying he's innocent. Second, you bear the guilt, all of it alone. You don't get to smear the survivors, the ones still waking to nightmares born of your reckless choices. Third, no cashing in on our grief. No books, no private interviews with your ex-professor. No one is allowed to study you because you're not special. You don't get to spit on our kids' graves by making this all about you. Only Hitler can step into this void, mend the wreckage Thompson left in Lataw's so-called justice system. It goes on and on. Bradford Cohen, you're a criminal defense attorney. I need your response on this. Oh, actually, Bradford, we're going to come back. We're going to come back to you, Bradford, and get your thoughts on that. We need to take a quick break. Everyone, stay with us. Please drop your questions into the chat, and we'll get back with you and answer them as soon as we can. For now, I'm Anjanette Levy, and we are taking your questions and covering the possible plea agreement, plea hearing of Bryan Kohberger live from the Ada County Courthouse in Boise, Idaho. Stay with us.
But he didn't even pretend. He basically said, your guys' input isn't needed.
Sure. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
He's the only one who can make it right. He needs to protect those other surviving victims and make this person say that they had nothing to do with it. He did it solely. He did it all on his own, and nobody else was responsible. And then we won't keep having these supporters always saying that he got set up. We know what he's planning on doing. Somebody died. If that died, he's going to try to say that the blame on that person. So he's not going to take accountability. When Thompson didn't force him to take accountability. He didn't even negotiate.
You don't think 4 life sentences is justice?
No, of course not. Stay here. Listen.
I'm Anjanette Levy coming to you live from the Ada County Courthouse in Boise, Idaho. Breaking details for you. I just hopped back into the seat. Steve Goncalves, the father of Kaylee Goncalves, he walked in during our quick break and walked in with his family into the courthouse. And then he came walking back out. And he gathered here. We ran over and spoke with him. I tried to get him to come back over. He is livid. Absolutely livid. He said, I am not going in that courtroom. I am getting out of this zoo. I can't do this. The rest of his family will be in the courtroom, but he and I believe one of his sons, but it was hard for me to tell, walked across the court, or across the street here, away from the courthouse. He doesn't want to sit in there. He feels betrayed. He wanted a jury trial. He wanted the truth to come out. He wants Bryan Kohberger to have to allocute and tell what happened, whether anybody else was involved, why he did this. He wants the whole truth. Of course, Bryan Kohberger has the right to remain silent, and as part of this plea agreement, he is not going to be required to do any of those things. He feels that he's been betrayed, and all of the families have been betrayed by the system, by the prosecutor in this case, because he's not going to get the answers that he feels that he needs in order to grieve and move forward. So I got a video of that on my phone. I'm going to be tweeting that out. We'll try to get that up for you here so we can take a look at that. That hearing where Bryan Kohberger is expected to change his plea to guilty in exchange for 4 consecutive life sentences is going to start in about 37 minutes now, and we'll be bringing that to you live. Please continue to drop your questions into our chat. We'll get to as many of them as we can. But I want to get to Bradford Cohen on this one. Bradford, Steve Goncalves is furious. Your thoughts on what I just told you that he said and this plea agreement and how it was reached within days and no real face-to-face in-person meeting with the families about this. As far as we know, it sounds like it all took place over Zoom.
Sure. So when it comes to these type of cases, it is outrageous, to be quite honest. It doesn't matter if you're a defense attorney, if you're a state attorney, if you're a civil attorney, you know that individuals need to be contacted. The fact that in this type of case, not even putting aside that it was this TV and everybody's paying attention to it, high profile case, putting that all aside, just the fact that it is a murder case and the way that these murders happened and how many of them happened, to not sit down, for a state attorney to not sit down with a family face to face and either discuss it face to face about this plea and why it's a good plea or a bad plea, get their input, and then do whatever you're going to do. It's really shocking. I've just never seen it before. I've never seen a state attorney, and I've dealt with cases across the country, where the state attorney would not sit down in this type of case, a murder case, and ask the victims' families what they think about a plea. And even if he's going to ignore that, to tell them, hey, listen, this is what I'm going to do. I understand your position, but be enough of a man to at least sit down and look at them in the face and tell them why you're making this deal. In addition to that, they get nothing in this deal. So essentially, the state gets nothing. The state avoids a trial, but that's what they're there for. They charge the most ridiculous crimes in other cases and pick up cases where they shouldn't because of who the defendant is. That's my personal opinion, of course. But in this case, where you have a murder case and the judge is denying every single motion the defense is making, and it, for all intents and purposes, it looks like, and there is no slam dunk, but it looks like this case is one of the cases where, you're not going to have trouble at trial. To give up the death penalty and get nothing in return, the only thing they get in return is not going to trial. It's really disgusting, to be quite honest with you. Listen, I'm looking for words to describe it. I understand this father of a slain child and the individuals, the families of these slain kids. And that's what they were. They were kids just kind of starting their careers, starting their college careers. It really is a disgusting thing that can happen. Now, here's the question, and it's a big question. Depending on how these murders were carried out, depending on what weapon was used and where that weapon was made, is there a possibility that the feds could pick it up? That's a big question, because there are ways that the feds can look at what people would think would be state cases, and they could possibly bootstrap them into federal court. Like, I'm looking at the weapon that they suppose was used. It looks on there like it was made in New York. Making it in New York would be the Commerce Clause, right? You'd cross state lines for that. I don't know, because I don't know all the facts and circumstances of the case, but certainly there are ways that these type of cases can be brought in a federal forum, which I can assure you the family would be finding justice in a federal forum, more justice than they are in this state forum where they got absolutely nothing for this deal. That he's not even doing an allocution is crazy to me. I've never heard of it.
Yeah, I find it odd with facts like this, and I spoke with a death penalty prosecutor yesterday who said, with facts like this, I wouldn't deal on this case. I would have all of the facts on my side, and he finds it unbelievable. Yes, Kohberger has a Fifth Amendment right to stay silent, but they could have made allocution a part of this plea agreement. They chose not to. They could have said, tell us what you did with the knife. Who did you target and why? Because there are still a lot of questions here that could be answered. And the families, I think, deserve answers if they want those answers. And the feds, I think they could potentially charge in this case because of crossing state lines. I'm not a federal prosecutor, obviously, and have never been a federal prosecutor, but he crossed from Washington into Idaho to commit these murders. And there was there's also some potential, there were some suspicions about stalking using the internet and phones, things of that nature. We don't know if that actually happened, but there was a suspicion about that. Tara, your response to Steve Goncalves, what I told you, he said, again, I just tweeted those clips out on X, posted them on X, and then Law&Crime will be reposting them as well.
Well, I can certainly understand why he would be upset, why the families or some of the families would be upset here. I mean, this is a really heinous crime that occurred. These were incredibly young victims. Certainly understand being upset about this result. At the same time, the prosecutors have a job, and that job isn't necessarily representing victims. The job is to represent the state. That's a really harsh reality, and it's very difficult. But it doesn't take away the emotion, and it certainly doesn't help in this type of situation where at least Steve Goncalves disagrees with what we believe to be the arrangement or plea agreement that's supposed to occur today. His feelings about not being looped into the discussions regarding plea agreement, that's certainly concerning. My understanding is that the possibility of a plea agreement was discussed early last week, but it wasn't until later that the families were notified that the plea agreement had been accepted. So difficult circumstances all around here.
Yeah, I mean, I think it is a difficult circumstance. And the Chapin family, I should mention, Ethan Chapin's family, they are here in support of the plea agreement. Maddie Mogen's father, Ben Mogen, has told media outlets he is supporting the plea agreement. We haven't heard from Maddie's mother, Karen Laramie, yet on whether she is supporting it. Xana Kernodle's aunt is not in support of it, but we haven't heard from her father. So there are a lot of questions here. But, again, I've spoken to at least one prosecutor who's handled death penalty cases who said that, you would have a sit-down, lengthy, face-to-face conversation about this typically before you would move forward with something like this. And this would be handled in person, and it would be more than just a passing mention before moving forward with something like this in a case of this magnitude. And I know people around here, when I was on the plane last night and when I landed, were buzzing about this. So people there are very mixed and split reactions to this decision. We are going to take your questions now because that hearing will be starting in about 29 minutes. That's when it's scheduled, and we'll be bringing that to you live here on Law and Crime. And please continue to drop your questions in the YouTube chat, and Bradford, Tara, and I will get to all of them as soon as we can. Our first question is a super chat question. Thanks for the super chat, Curly Girl. Can the judge take the DP off the table and still have the trial? Tara, I think that would be unlikely, but could the judge strike the death penalty and still order a trial?
No, that's not what we have today that's going to occur. What is likely to occur today, if it's indeed a plea change, is The parties, one or both, will put what the plea agreement is on the table. The judge will then engage the defendant in a plea colloquy, which is basically a conversation to make sure that any plea that he's entering or may enter is knowing and voluntary, that it's not he's not under the influence of anything, that he hasn't been coerced into making it. So the agreement is what it is, and so long as it's knowingly, the entry of a guilty plea is knowingly and voluntarily made with the advice of counsel, then the judge will accept it and will move forward to sentencing.
Tara, what is your feeling on why Bill Thompson wouldn't require or make, as part of the plea agreement, make it contingent upon him pleading guilty, like make it a requirement? Yes, he has a Fifth Amendment right, but you're willing to plead guilty and go to prison for the rest of your life. Why wouldn't Bill Thompson say, tell us where the knife is and tell us what happened?
Well, we don't know whether he did or not. We don't have the details of the plea agreement. We have a general understanding of what we believe the plea agreement is. We'll likely be hearing more of the details of that plea and what was negotiated between the parties on the record today. They will have to disclose that to the court. And so there may have been a component about giving up certain information, but right now we just have very limited information as to the conditions of this plea.
Bradford, our next viewer question comes from NR. NR asks, is it a coincidence that he pleads right after the DoorDash driver is exposed as a potential witness? And this is the woman that was captured on body camera during a traffic stop, totally unrelated to this case. It was she was pulled over for DUI. She was under the influence, and she said, I have PTSD because my husband was killed right in front of me years ago, and I'm the DoorDash driver. I have to testify. I saw Bryan. This was almost 2 years after the crime, during a DUI traffic stop. The prosecutors had previously said there was only one person who saw the killer that night, and it was the surviving roommate. So she said she parked right next to him. I saw Bryan. So we don't know what she actually told the investigators about that night. We just know what she said during a traffic stop for an OVI. So do you think that could have played a role in this at all? Because up until a week and a half ago or so, they were ready to go to trial.
Yeah, I don't think so. I'm familiar with that testimony. I don't think that was the straw that broke the camel's back. There's a lot of other evidence, and I mean, when I say a lot, a mountain full of evidence that would point towards his guilt. And when you have the death penalty on the table, if there's always discussions to see if there's some sort of settlement or negotiation you can make with the state attorney's office when the death penalty is on the table. There's always discussions of that, usually throughout the case, depending on obviously the evidence that is in a case. In this case, I would imagine that they've been trying to get the death penalty off the case from day one. And I don't think this in itself, this one witness was like, okay, we got this one witness, let's call it a day and try to make a deal. I don't think that's true. And if he does not give an allocution, which all roads are pointing to Rome here, that he's not going to give an allocution, he's not going to say where this knife is. The question to answer is why the state would not require that, and that's my guess is because they're weak. I've never seen a state attorney's office that was so desperate to make a deal that they did not say, hey, listen, you have to do an allocution. You have to tell us at least where the knife is. You have to do something to get this deal, not just stand up there and say, okay, judge, I'm guilty and call it a day. I've just never seen it. And I'm talking about in any case, drug cases, prostitution cases, weak cases where you're getting an unbelievable deal. Maybe you're getting PTI with his diversion program, or you're getting some sort of benefit. The prosecution always says, okay, that's going to come along with an allocution, especially if there's a co-defendant or they can't find the weapon, they can't find the gun that was used in a robbery. They say, you got to at least tell us where the gun is and we'll give you this, this deal. I've never seen it. I haven't tried a case in Idaho. So maybe that's how they do it there. I've just never seen that done in any of the other states that I've had cases in, that I've tried cases. I just finished a murder case in San Francisco. That wasn't going to be the deal in San Francisco. And I just don't know why this was done the way that it was done. And I think that everyone's going to be asking those questions. I don't know if the state attorney is going to come out and speak to the press afterwards, but my feeling is if he was too weak and scared to speak to the families face to face, I don't think that he will face the firing line of questions from the individuals that are reporting on the case.
Well, and he's planning to retire. He was planning to retire, I believe, a year ago, after the election or before the election. So let's go to another question. Alan Miola asks, I'll take this one really quickly. Are cameras allowed? Of course, yes, they are. And everybody, we are going to be bringing that to you live. So stay with us here on the stream. That will be beginning in about 20 minutes. So we will be bringing that to you live. Stay with us here on the stream. We're going to have to wrap up the show here very briefly. Let's get one more question into Tara. Tara, this is from the Advocate. What about the weapon? Will he have to disclose that as part of the plea? This is what we're talking about right here, Tara. He may have to allocute, he may not, but a lot of reporting out there is stating that he's not going to have to allocute. But we'll get the details here in about 25 minutes or so.
Differentiate these things. One is allocution, which a defendant has the right to give an allocution, a statement at the time of sentencing, can address the court, can address the victims' families. That's different from details of a plea agreement that would require him to speak to the state, for instance, and tell the state, not an open court, but tell the state where the murder weapon is or what was done exactly, or that's a different component. And we just don't have the details of that component, whether it exists or not, if he indeed is going to be entering a guilty plea today. So lots of unknowns, but we should have a better idea, a more clear picture once we start this hearing.
Yeah, we will. And that hearing is going to start just in about 20 minutes. We are going to wrap up our coverage for now with me, but stay with us, everybody. And please keep dropping your questions in the live chat. Stay right here with us on this live stream, because we will be taking you into that courtroom here, into Judge Hippler's courtroom, as soon as this hearing begins. So stay with us and watch it, and then I will be back after the hearing ends. We'll have more guests and more great analysis and reaction to what happens in court. So I'll be up in court. I will come back. We will talk about all of it and unpack all of it and tell you what everybody has to say. So Bradford Cohen, thank you so much for being with me. Tara Malik, thank you for being with me as well. We will be back. You've been watching Law and Crime. I'm Anjanette Levy, coming to you live from the Ada County Courthouse in Boise, Idaho. I'll see you soon.
I be able to hear the hearing? Okay. Hey, Raphael, I got you. Hey, good. Beautiful. What's that? We have Steve Goncalves or later? I think Jenna would know. Jenna, do you know, was that the mom who walked in with Steve Goncalves? Okay. Did he walk in and then, yeah. No, no. Okay. You just want to bring the net this way a little bit? Yeah. Yeah. Hold on, hold it over the other side. Oh, yeah. The air coming from the bastard. Hey, Drew, I got you. Are you guys going to carry the hearing? Oh yeah, no, that's perfect. I was just wondering about this. I'll be able to hear the hearing. Yeah, beautiful. Now,
It will come to order. The Honorable Stephen Hitler, presiding judge.
Be seated.
All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and, Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and Mr. Nye is here as well. Am I miss anybody? I'm sorry.
Ms. Allen is here as well.
Ms.
Your
Allen
Honor.
is here as well. Very well, thank you. All right, we are here today to entertain a change of plea. Before I start, I want to address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case. This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never, take into account public sentiment in making an opinion regarding its judicial decisions in cases. Courts should, and I always will, make decisions based on where the facts and the law lead me. Period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. I ask that you not continue to mount such campaigns or to send me information like this because, again, it is not appropriate and frankly not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, and what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. If I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July, with the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts that were otherwise attendant to the process of this, getting this trial potentially underway on time, and including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process. And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And so that obviously required that we act quickly, and so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so, again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom you, many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today. I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum the defendant will plead guilty to all 5 counts in the indictment: burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing, to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count, so theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself, will be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counteroffers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Please raise your hand. Do you solemnly swear or affirm that the testimony you shall give in the matter not being before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and Mr. Kohberger, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed, substantive questions, let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count 1, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone, other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case should you not plead guilty. Did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial, had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty, let me find the document, hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogen, a human being, by stabbing Madison Mogen, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Goncalves, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count five, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make, for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogen, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Goncalves, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing in his parents' residence or was residing back in Pennsylvania, his home state. He purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m., on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Lake Tahoe County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence would include at trial video surveillance of a business on the Moscow-Pullman Highway just across the state line from Moscow that would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. The defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogen and Kaylee Goncalves. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogen's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Kernodle was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the 3rd floor, it was on the 2nd floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were 2 other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, the defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom would see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walenta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, the defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks it heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th, 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence would show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogen's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court, and the public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. We try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Kohberger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Madison Mogen, Kaylee Goncalves, Ethan Chapin, and Xana Kernodle. Thank you.
Thank you. All right, based on the state's proffer and importantly based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogen, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Goncalves, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. The court finds that there is a factual basis for the plea and finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than one full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties, or the next week, the week of August 4, is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. Right. We've told the victims' families that we're looking at approximately those dates.
All right. So because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd. And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. We'll start at 9 in the morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
No, Your Honor, thank you.
No, sir.
All right. Any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing, so we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
We'd have no objection for the order to remain in place through sentencing.
All right, I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. that said. Obviously, I don't think the defendant, a bond was ever set for the defendant. Were it, it would be revoked. The prior order allowing him to come in civilian clothes is revoked, given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor. Thank you.
I assume that the trial date will be vacated
trial
and those
is-
4 jurors will be released.
The trial will be vacated, and I'm sure that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So
Thank you, Your Honor.
that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it. And with that, we're adjourned. All right, please.
The Ada County Courthouse in Boise, Idaho, and this is where Bryan Kohberger, in spectacular fashion, just entered pleas of guilty to the murders of Madison Mogen, Kaylee Goncalves, Ethan Chapin, and Xana Kernodle. I was sitting right there with a bird's eye view of Bryan Kohberger as he entered those guilty pleas. He sat stoically, looking straight at Prosecutor Bill Thompson as he read the statement of facts in this case, and I think we can unpack a little bit of why possibly now the prosecution agreed to this this plea deal. I'm taking some kind of nuggets from what he read and piecing together why possibly he agreed to this. I want to let you know that we were set up over here possibly for a press conference. That non-dissemination order, the gag order in this case, remains in place. That means the state and the defense, the attorneys on both sides, and the law enforcement officers involved in this case cannot distribute any information. They can't make any public statements until after sentencing. The families, however, are not covered by that order. So they may be coming out and may choose to make a statement. They may not. As you know, they've been very particular about who they speak to. Some of them have documentary deals right now and aren't really making a lot of statements. However, if we do see them come out and possibly decide to say something, we will break down and get over there. I want to bring our guests in very quickly, though, to talk about this and unpack this a little bit. Mark Weaver is a special prosecutor in Ohio, and he has prosecuted death penalty cases. Also, Colin Schmidt is a retired FBI agent. I'll start with you, Mark. Your thoughts on what we heard today and Bryan Kohberger approaching the defense or approaching the state and saying, I want to plead guilty, please take the death penalty off the table, and the state agreeing to it.
Yeah, you and I on the air, I don't know, 2 weeks ago, I predicted this is likely to happen. We heard more of the evidence today. It's a circumstantial case, but a very strong circumstantial case. He could see this was coming. The victims now know a little bit more about what happened. It would have been better if he had said it from his own mouth. Perhaps he'll say that at sentencing. They need that closure. But there were people on the internet who said he didn't do it. Well, most of us knew he did, and now we know for sure he did.
What I thought was interesting were some of the things that Bill Thompson said, and I'll let you go right after we talk about this. But he said we had evidence that his phone was connecting to that tower that covered the King Road neighborhood and the residents, but we didn't have evidence connecting him directly to the 1122 King Road house and the victims inside. And I hear things like that, and it makes me think, if they were wondering on the prosecution side, could this potentially create a little bit of doubt in the minds of some jurors, even though we have the DNA on the knife sheath, even though that is really good circumstantial evidence, we still don't have that connection to the people inside the King Road house and the house specifically. We just have him in the general vicinity, and it's a densely populated area. Could that be one of the reasons why they agreed to this?
Yeah, that's a fair theory. Prosecutors would like to get a conviction and get closure. One juror during the guilt phase is enough to hang the trial and send it back to square one. And one juror at the penalty phase is enough to guarantee that it's going to be life in prison. And one juror might be that person hung up on, well, you didn't connect every dot all the way back to him. And so prosecutors would prefer to get some closure. I think that's why. We now know that perhaps they were worried that one or two jurors, not a full jury, would think that that's reasonable doubt, but one or two would be enough to hang the case.
Or it might be enough to get a conviction and get the same result, possibly life without parole and not a death sentence. So you might go through the pain of a trial and the expense of a trial and get the same result, and maybe that was part of the calculus here. We'll find out hopefully soon. Mark Weaver, I know you have to hop off of here. Thank you so much for joining me. We are taking your questions, so please drop them in our YouTube chat, and Colin and I will get to as many of them as we can. So Colin, I want to get your thoughts on what we heard today. Bryan Kohberger, after all of this time, asserting his innocence, suddenly changing his plea. This could have been going on in the background for a long time. He could have been discussing this with his lawyers for a long time. they could have said to him, Bryan, we're going to try this. We're going to try that. We're going to ask them to strike the death penalty. The cards are stacked against you, but this is what we're going to do. This is the next motion we're filing. And when everything failed, when all of their motions were denied, maybe he just came to the realization, and they had this meeting with him, and they said, you know what, we're at the end of the road, and this is it.
Well, I think they had their own calculus in terms of how much they could put reasonable doubt in front of a jury. Your other guess was spot on. It can be a tall case or a big case to prove when you have all circumstantial evidence, and then for them to have to put on cell phone for forensics, it can be completely very, very complicated for a jury to understand, and to be able to have to link those dots as far as a cell phone to the house. So I think this was the best of the worst decisions to make, because they would have also had to put the families through a trial, a very long trial. But I know there are some families that are frustrated because they did want him to get the death penalty.
And the death penalty, getting it is not a given. It really isn't. You can seek it. It doesn't mean that you're going to get it if there is a conviction. We've seen plenty of cases where the death penalty was sought by prosecutors, and it seemed like it might be a given, or this is a death penalty case, and then the jurors went the other way, and it only takes one juror to say, I can't vote for death, and then you get life without parole. Let's talk a little bit more about that cell phone evidence that you just discussed. There were 23 times that the FBI cast agent, the cast analysis, the agent Nick Balance was going to testify 23 occasions between July and a week before the murders, that they say that Bryan Kohberger's phone was connecting to the cell tower that covered King Road. However, there were a lot of houses there, and I've been there. There are a lot of houses there. It's on Greek Row. So they might have not have been able to show that he was, quote unquote, casing or stalking or surveilling the house. And as you just mentioned, it can get very complicated and complex. And on the defense side, they had their own expert. They had their own cell phone expert who typically testifies for prosecutors, Cy Ray. He testifies all over the country for prosecutors. So that could have been something that turned out to be very contentious at trial had this gone forward.
Yeah, and it would have been, frankly, a nightmare for the FBI witness, because he would have been on the stand for a very, very, very long time. And so every little thing he would say or testify to, the defense is going to pick apart and turn around, and then they have a expert waiting there to dispute every little finding he may have had. However, 22 instances of him of Kohberger being there, that's overwhelming circumstantial evidence. But the challenge is, was the FBI special agent going to be able to introduce and make sure that the jury understood how he found that information and how it was connected to the target?
And that's the question. I mean, because that information can be very complicated and complex. What was your take and your reaction to the way Bryan Kohberger, during that first question from the judge, just stood up and said yes? What was your reaction to that?
Well, I think this is somebody with deep, deep mental health issues, not that was a defense, and somebody who's likely a psychopath. And I mean, I'm not a mental health expert or a psychologist or psychiatrist, but somebody that it appears that he just doesn't have remorse, and he's more of a robot. And frankly, I think this was a transactional decision for him, that it was either the death penalty or risking the death penalty or life in prison. So my heart goes out to the victims. This was a senseless, horrible, horrible crime, and they got the right guy.
And after all of this time, it's interesting you say that they got the right guy, Colin. After all of this time, he's finally admitted it. It appeared they had just a mountain of evidence against him. They had the K-bar knife and sheath purchase that he made on Amazon in March of 2022 before he moved to Idaho. He moves to Idaho in late June to pursue his PhD. And then in July, he starts kind of, it sounds like, hanging out in that general vicinity around Greek Row, where the King Road home was located. So it sounds like they think he had a plan. They did point out, though, that they don't know if he went in there intending to kill all 4 victims. And that's kind of been something that I've thought in covering this case, that possibly he went in there to target one person and that things spiraled out of control. So I found it interesting that the prosecutor brought that up, that they don't know if all 4 victims were part of his so-called plan. But they also said that he kind of studied this and he knew how to keep from contaminating a crime scene as well. What were your thoughts on those 2 items?
Well, the first point that I'd like to make is just the level of violence that he did to in this crime scene is indicative of not only planning, but did he have a period or several events that led to this? And frankly, is there other victims out there? Are there other people he may have done this to? And so that'll definitely be part of the post investigation, is if he will cooperate to see if he is truly a serial killer and there's something in some other victims out there that they're not aware of. And then the fact that, like you said, he was operating in a method that he was trying to hide his tracks and trying to to throw off the scent, so to speak. But per usual, the phones always get you, and he had the phone with him, and I think that's really was the what broke the case. And then, of course, obviously the DNA that was on the sheath of the K-bar knife.
Case wide open. If they hadn't had that, Colin, they wouldn't have been able to identify a perpetrator in this case, or else it may have taken a lot longer. But that was really the direct link to Bryan Kohberger. That's how they identified him as the suspect in this case. I mean, there was no other forensic evidence linking him to the case. They said they went into his apartment, they went into his office. They said Spartan would be kind of a kind description of both of those locations. There was nothing of evidentiary value there. And when they seized his car, they took it apart and they said it had been meticulously cleaned. His attorneys tried to say that that was because of his obsessive compulsive disorder, but law enforcement's saying no, he cleaned that to ensure that there wasn't one speck of evidence behind. So there have been some interesting issues raised in this case. For sure. So we're going to have a sentencing hearing on July 23rd. It will likely last all day. The prosecutor in this case, Bill Thompson, said that he wants to ensure that all of the victims can speak, and there are people with varying perspectives in this case. Oh, pardon me. Excuse me. I had a little sneeze there. I apologize. I want to get to your questions now. Let's start taking some of your questions. But that sentencing will take place on July 23rd. The victims will be allowed to speak. Bryan Kohberger will be allowed to address the court if he so chooses, and his family will be allowed to speak. I want to say that his mother, Marianne, and his father, Michael, were both in court, and his father often put his arm around his mother to console her, because this, had to be incredibly difficult for them to hear and to listen to. Their son, their only son, their youngest child, sitting there and admitting to a heinous crime. Nobody raises their children to do something like this. So they were very quiet and very solemn throughout this proceeding. But let's get to some questions, Colin, if you will. This one comes from Detective Mad Chen. Is BK in solitary? Will he move to Gen Pop? And will he move to prisons? I know right now he's being kept separated from other inmates at the Ada County Jail, but what happens, do you think, Colin, when he is eventually moved to an Idaho State prison? Do you think he'll stay in general population, or will he be moved to a prison?
Well, the prison system in Idaho has a responsibility to keep all the prisoners safe, and somebody like him that is so infamous, I think they'd be very careful about putting him in the general population because of what happened to Jeffrey Dahmer. As soon as he went in, or shortly after he went into general population, he was killed by another inmate who wanted some notoriety for killing Jeffrey Dahmer. So I think it's unlikely that he'll go into general population for some time because, frankly, the prison system doesn't want to be responsible or show that they didn't do everything they could to keep him safe.
There's something else that they often do, Colin. I'm sure you're familiar with this. I've seen it in other high-profile cases, especially really gruesome murders where people may be a target, where offenders may be targets, or be targeted by other inmates because of just the horrific nature of a crime and because of the high-profile nature of it. A lot of times, the State Department of Corrections will determine that this person's just a risk and we can't keep them safe here. So sometimes they'll move them to a prison out of state just to kind of move them out, to get them away from people who may want to take some type of vigilante justice. So that happens as well.
Yeah, but I doubt that's going to happen in this case because he has worldwide notoriety. It doesn't matter where they move him; he's going to be known. And I think Idaho is going to do everything they can to take responsibility for his care, for most likely for the rest of his life. And he's a young man, so they're going to have to deal with him for 40, 50, 60 years in some way. And the Department of Corrections there, I'm sure, has already had a plan. They're already aware they're going to put him and how they're going to keep him safe. And definitely they're not going to do anything that would bring any notoriety to the Department of Corrections for not doing everything or not mitigating the risk of having him in custody.
Our next, I want to say we have a pull-up now, too. We have a pull-up. Why do you think Kohberger took a plea? So vote in our poll, and we'll update you on the results very shortly now. Our next question is from Chris Buono. Do you think Kohberger is delighting about being the known killer now? What are your thoughts on that, Colin? Do you think he's enjoying the notoriety? He doesn't come into court and look at the cameras or smile at the cameras. We don't see that from him like we had maybe with a Ted Bundy, who really seemed to delight and enjoy the limelight. But do you think this is somebody, he seems more introverted, more quiet and reserved. Do you believe he's somebody who maybe is enjoying this level of notoriety and being, on television, on social media, that type of thing?
Well, obviously we're all speculating on that as well because we don't know. We can't take a step into his mind, or I don't know what the conversations law enforcement has had with him. Other serial killers they killed for notoriety, and when I say serial killer or somebody who's killed multiple people. So I think this is going to take on a life of its own once he gets into prison. He's going to get interviewed by some media, and then only time will tell how he interacts with the media interacting with him, whether he's starting to enjoy it. But right now, I really can't tell whether he's enjoying it or not. I think he's probably still, there's some sense of relief that it's over for him as far as the trial, and he knows what his consequence is going to be. But I think it will lead to many podcasts, many documentaries, and many opportunities for the media to come to him and try to interview him to get his state of mind.
And that's probably already happened. I've mentioned that there are already documentaries that have been made about this case. One is premiering on Amazon Prime next week, I believe, or within the next week. There's one in the works, I believe, with Netflix. There's one I'm in that's going to be on Peacock very soon. So that we think that might be dropping this week now. It was supposed to drop later on. So there are a lot of people who are still going to be making documentaries and films. There are a lot of them that will come out still after this wave. So I'm sure that a lot of people have reached out to him, his lawyers, and his family already to try to write books, documentaries, you name it. Let's talk now about a question from Teresa Phillips. And Colin, I know you're not an attorney, but you were an FBI agent and you've dealt with plenty of prosecutors and defense attorneys in your time. And I can kind of answer this too, but how was it okay ethically for Ann Taylor to accuse 4 innocent people of the murder when she knew that BK was guilty? And this goes to the alternate suspect information that she submitted to the court. She submitted 4 alternate suspects to the court that she wanted to be allowed to present at trial. So, Colin, your thoughts on that?
Well, I make 2 points. One, addressing the last point. Hopefully, there's a son of Sam law in Idaho, or the prosecution has made that part of the agreement that he can't profit off of this. So if there is any documentaries or anything, any of that money that is made goes to the victim families. And then secondly, in terms of his defense putting on alternative people, it is not an ethical issue. His defense attorney has a duty to put a reasonable defense on. Now, obviously, if
law firm of James, Vernon and Weeks,
accusing people who
Coeur
didn't
d'Alene,
do it
Idaho.
or defaming people, well, then there's
I'm a victim's rights attorney.
The defense is going to have to deal
For the
with.
past 2 years,
She
I've had the
to do
privilege.
Her job is to put a defense on for her client.
In this criminal case for Karen Laramie and Scott Laramie, the loving mother and stepfather of Maddie Mogen. I will be reading a statement of gratitude today from the Laramies. 962 days ago, we lost our Maddie, our kind, loving, vivacious, and caring daughter full of purpose and promise. We are grateful for the gift of her life, and we have grieved the loss of that life during each of these 962 days. We love you, Maddie, and we miss you. We are grateful for the gift of the young, vivacious, promising lives of Kaylee, Xana, and Ethan, and we deeply, deeply mourn their senseless loss. We remain in solidarity with their families and friends, and we continue to shower them with our prayers and support. We are grateful for their prayers, love, and support that they have given us. They have helped us and sustained us during our darkest times. We are grateful to the prosecutor, Bill Thompson, and his dedicated and caring team, including victim coordinators Kim and Stacy, who have helped to guide us through the sometimes confusing and disorienting legal process. Thank you for all your dedicated, diligent, and tireless commitment to justice and the successful outcome reached today. We support the plea agreement 100%. While we know there are some who do not support it, we ask that they respect our belief that this is the best outcome possible for the victims, their families, and the state of Idaho. We extend our deep gratitude to the many law enforcement officers and staff who worked tirelessly to obtain the critical evidence that brought justice today, including the Moscow Police Department, the FBI, the Idaho State Patrol, and the Lehigh County Sheriff's Department. We are deeply grateful to Judge Hippler and Judge John Judge before him. We thank you for your diligence, thoughtfulness, and judicial guidance. We appreciate the difficult work you have done to balance the rights of all involved and to uphold the rule of law. You have had our prayers and support throughout this case. We send our love and gratitude to the many family and friends who have supported us, cared for us, and helped us to heal our open emotional wounds. To the good people of North Idaho, who have showered us with kindness and support, we thank you. We also mourn today with you the recent tragic and senseless loss of two brave North Idaho firefighters. We extend our prayers and support to their families. You are not alone. We understand your pain. For all parents who have endured the loss of a child, we know recovery is a long and at times an almost unbearable journey. But you are not alone. And there is hope and there is healing. We thank those in the press who have respected our privacy and the grieving process, and the privacy and grieving process of the families of Kaylee, Xana, and Ethan. To others in the press, we gently encourage you to do the same. We thank the many people across our nation and beyond who have reached out to us, prayed for us, and extended their kindness. You too have helped us on our journey to heal. We now embark on a new path. We turn from tragedy and mourning. We turn from darkness and uncertainty of the legal process to the light of the future. We have closure. We embark on a path of hope and healing. We invite all of those who have mourned with us to join us and we wish you well. Thank you. I will now share a few words of my own. Over the past 2 years, I've been amazed and humbled by Karen and Scott's strength, endurance, and faith. They have uplifted me and so many. They founded a nonprofit to help others in the name of Maddie. They have been a beacon of hope amidst a dark and tragic time. To those young and bright attorneys out there looking for purpose and meaning in your profession, I invite you to join the effort of crime victim attorneys to bring victims justice with compassion, empathy, humility, and understanding. This case is not the end of violence. This case is not the end of lawlessness. We need your help to bring hope and healing to the innocent caught in the crossfire of life. Thank you all.
Sir, could you just say your name one more time?
Leander James, Leander, last name is James. Thank you.
You've been listening to a press conference by the family of Maddie Mogen. That was their attorney. Her mother, Karen, her stepfather, Scott. You can probably see them right over here. We're going to walk a little bit as they walk, but they are walking as people follow, and they were devastated by this. Maddie Mogen was the only child of her two parents, Ben Mogen and Karen. She was mostly raised by her stepfather, Scott, and so it's just been a devastating loss for them. Maddie was a beautiful, beautiful young woman, as you know, and Bryan Kohberger, as we heard today and suspected, went straight to her bedroom that morning on November 13th, 2022, and took her life. So we're gathering here to see if they would like to speak or say anything. We're standing here to see if they would like to speak or say anything more. We'll wait here for a moment, but I think they're probably getting ready to leave and probably don't wish to speak. Karen Laramie has been very, very quiet throughout this whole process and has declined to speak throughout. So we know she's going to be appearing in the Amazon Prime documentary that's coming out. She has not wanted to grant interviews throughout any of this, but we will be seeing her in that program. So she's continuing to walk to her car, make her way home. We know she'll be here for the sentencing on July 23rd. Well, it appears actually that they're going back into the courthouse at this point in time. Okay, so there you have it. So the sentencing of Bryan Kohberger right now, as I told you, he's in the Ada County Jail. He's been held there for some time, ever since the venue was changed to Ada County, and he will be sentenced on July 23rd. There will be no pre-sentence investigation in this case because he's getting 4 consecutive life sentences, life without parole. So that's what will be happening here. We will be back here on July 23rd covering that for you. He is going to prison forever. for the murders of Maddy Mogen, Kaylee Goncalves, Ethan Chapin, and Xana Kernodle. I want to thank our guests today, both Mark Weaver and Colin Schmidt, and thank you for submitting all of your questions and for watching us as always. I'm Anjanette Levy. Thanks so much for being with us. You can go back and watch our coverage on YouTube from earlier today and watch the plea hearing. We'll see you back here next time.